I represented myself in court. My boss laughed and said, "You can't afford a lawyer," and his attorney smiled. They all did. Then the judge asked one question and the room went silent. I worked as a graphic designer at a marketing firm called Apex Creative for 3 years. Solid portfolio work, decent pay at $52K, small team of 8 people. In May, my boss Jonathan called me into his office and pulled up a competitor's Instagram campaign on his monitor. "I need this by Friday," he said. Same fonts, same layout, same color scheme. I stared at the screen. It was the Riverside Coffee rebrand. Clean, minimal, distinctive. Their agency had won awards for it. "That's copyright infringement," I said. Jonathan laughed, not a friendly laugh. "Everyone does it. It's called inspiration. It's called copying." His smile disappeared. "Are you refusing a direct assignment?" I was. I told him I wasn't risking my license for a knockoff campaign. He told me to think carefully about my priorities. I left his office knowing exactly what was coming. 2 days later, HR called me in. Performance issues. Not a culture fit. Effective immediately. I cleaned out my desk in 14 minutes. I was angry, but I moved on. A week later, I got an offer from a startup called Bloom Digital. Better pay, equity options, actual creative freedom. I signed the offer letter on a Tuesday. Thursday morning, their CEO called me. His voice was tight. "We received a cease and desist from your former employer. You signed a non-compete. We can't risk litigation. I'm sorry." The offer was gone. Just like that. I pulled out my employment contract that night. Buried on page 7, 12-month non-compete, 50-mile radius, covering any marketing or design work. I'd signed it 3 years ago without reading it closely because I was 24 and stupid and excited about my first real job. Jonathan wasn't just firing me. He was making sure I couldn't work. I called 3 lawyers. All of them said the same thing. Fighting it would cost $8,000 minimum, maybe more if it went to trial. I had $1,400 in my checking account, so I filed a response myself, printed everything at the library, followed templates I found online, wrote a defense that probably sounded like a middle schooler's essay. The hearing was set for July 12th at 9 a.m. I wore my only suit, the one from my college graduation that didn't fit right anymore. I showed up 30 minutes early with a folder full of documents I'd organized by date, hands shaking the whole drive there. Jonathan walked in 20 minutes later. He wasn't alone. His attorney was a woman in her 50s with a leather briefcase and the kind of calm that comes from winning a lot. They sat across from me at the table, and Jonathan looked at my empty chair beside me. No lawyer, no backup, and he actually laughed. "You can't afford a lawyer?" he said, loud enough for the bailiff to hear. His attorney smiled, not mean, just amused, like she'd already won and was just waiting for the paperwork. The judge came in, middle-aged guy, reading glasses, stack of folders. He didn't look particularly interested in either of us. He reviewed the non-compete first, asked Jonathan's attorney to summarize the claim. She did. Smooth, confident, citing precedent. I violated the agreement by joining a direct competitor. Clean breach of contract. The judge nodded, flipped through pages. Then he looked at me. "Why were you terminated from Apex Creative?" The room went quiet in a way that made my ears ring. I pulled out my phone, opened my email, scrolled to May 17th. "He asked me to copy a competitor's campaign," I said. Pixel for pixel. I have the email. I handed my phone to the bailiff, who passed it to the judge. The judge read it, then read it again. His expression didn't change, but something in the air shifted. He looked at Jonathan. "You're enforcing a non-compete after terminating him for refusing to commit copyright infringement?" Jonathan's face went red. "That's not. It was a creative disagreement. A disagreement about breaking the law," the judge said flatly. His attorney started talking. Something about employment at will and contractual obligations being separate issues. Her voice had lost that smooth confidence. The judge cut her off. "This non-compete is unconscionable under these circumstances. It's void." He signed something, handed papers to the bailiff. "Case dismissed. Mr. Nguyen, you're free to work wherever you want." Jonathan tried to argue. His attorney put a hand on his arm and shook her head. I walked out of that courtroom with my folder and my too tight suit and called Bloom Digital from the parking lot. They hired me the next day. 2 months later, Jonathan got investigated by the state licensing board for the copyright violation. I didn't file the complaint. Someone else on his team did. Sometimes one question is all it takes.